On September 4, 14-year-old Colt Gray killed 2 students and 2 teachers with an AR-15, which was a Christmas gift from his father, Colin Gray. Allegedly, there were warning signs about Colt's behavior, and allegedly, Colin Gray allowed his son to access his AR-15. Assuming that all to be true, should Colin Gray be held criminally liable for his son's actions? The 54-year-old father now faces multiple serious charges, including murder, manslaughter, cruelty to children. Prosecutors allege that Colin Gray's decision to provide his son access to the weapon directly contributed to the tragic events at Appalachia High School. Should adults be held liable for the actions of their children? We talk about that today. I'm James Reeves. I'm the U.S. Law Shield program attorney for Mississippi and Louisiana. U.S. Law Shield does not sponsor this channel or this video. If you're interested in joining U.S. Law Shield, you can use the code NGGC. My range gets $20 or $30. You get a couple of free months of coverage for gun-related legal defense. The charges brought against Colin Gray aren't new, but they're part of what a Utah Law Review article referred to as a cyclical trend, where every couple of decades you see a spike in parents being charged for their kids' actions. It seems like we're in one of those cycles now. Back in 2021, Ethan Crumbley, age 15, killed 4 students with a 9mm pistol at Oxford High in Michigan. Crumbley was tried as an adult for 24 crimes, including murder and terrorism. He pled guilty to all charges and was sentenced to life in prison. His parents, Jennifer and James Crumbley, bought the handgun for Ethan, again, as a Christmas present. They were both charged with involuntary manslaughter. Instead of appearing for their arraignment, they fled and they were hunted down in Detroit by the U.S. Marshals. Personally, I'd rather go to prison than Detroit, but the Crumbleys did both. After getting caught by the Marshals, they were tried and convicted separately of 4 counts of involuntary manslaughter, and they both received the maximum sentence, which was 15 years in prison. If you remember the Highland Park shooter, when Robert Crimo killed 7 people at an Independence Day parade in 2022, his father pled guilty to misdemeanor reckless conduct. I don't know how these wacky-ass Illinois gun laws work, but apparently young Robert was not old enough to apply for a gun license, so his father sponsored his application, whatever that means. However, prosecutors apparently built a strong case that the father was aware of his son's propensity for violence when he helped him get his gun permit. As an example, a relative had previously contacted police about Lil Robert's threats to kill people. But how can a parent be charged with a crime committed by another person, their child? Involuntary manslaughter is a charge that most often arises when a death results from another person's gross negligence. In the context of parental liability, gross negligence would be, say, a parent's failure to exercise reasonable care when they have a duty to act, such as properly securing firearms, maybe not giving an AR-15 to your nut job kid. This is entirely plausible, and I think it's possible that Gray will be convicted of manslaughter just like the Crumbley defendants were. But how about second-degree murder? How can someone be charged with murder when they weren't even present when the murders happened? Gray was charged with 4 counts of felony murder, per the screenshot you see here from the Georgia Bureau of Investigation. Felony murder applies when someone's killed during the commission of a felony and the person charged directly participated in the felony, even if he didn't kill anyone. Perfect example. Think of Waingro killing the armored car driver in Heat. While Waingro committed the murder, the rest of the Heat crew, they were all participating in a felony when the death occurred, and they would all be charged with felony murder, even if only Waingro, who'd be charged with second-degree murder, pulled the trigger. Here, Colin Gray didn't directly take part in the shooting, his son did. That raises the question, can Colin Gray be held liable for felony murder when he wasn't actively involved in the crime? It's possible these charges could be dropped or reduced. I'm not a Georgia lawyer, but if felony murder works in Georgia like in other states, it might be difficult to pin felony murder charges on someone who wasn't aware that the felony causing the deaths was occurring. Georgia's felony murder statute, pretty simple. It says a person commits the offense of murder when in the commission of a felony, he or she causes the death of another human being irrespective of malice. I could maybe see if Georgia had a child access prevention law, maybe that could be a felony that he was committing, which led to the deaths in this instance. But he's only been charged with murder, manslaughter, and cruelty to children. I don't see any felony charges for an active, ongoing felony that he was participating in that led to the felony murders. But could Colin Gray be found guilty of manslaughter? The Crumbley case shows us that, yes, not only is this possible, but I would say probable. Now, should he be? Different question. Many states have parental responsibility laws, which impose criminal liability on adults under the premise that their failures to take control as parents led to their kids' bad acts. Some states also have child access prevention laws that hold parents accountable if they fail to secure their firearms from children. The former can be used for active negligence, i.e., you gave your child a gun when you knew he was hearing voices telling him to shoot up his middle school. The latter, child access prevention laws, they typically focus on passive conduct. For example, Florida's child access prevention law makes a gun owner criminally liable if he should have known that a person under age 16 is likely to gain access to the firearm. Another example, in 2022, Nevada passed the Liability for Minors Negligence or Willful Misconduct Regarding Firearms law, which held that parents could be civilly liable for their children's use of a firearm if the parent knew the child had behavioral issues in the past. Should parents be held accountable for the actions of their children? Parent gives heroin to their kid and she kills herself with it. Should the parent be culpable? What if the parent entrusts his 9-year-old with a car and the kid runs over a pedestrian? Or a parent lets his 14-year-old and his buddies play with a chainsaw to sleep over, someone loses a hand. Should that parent be liable? If you think any of those examples should result in liability for the parents, do guns alter the landscape of this responsibility for you? In other words, does the Second Amendment protect parents' rights to provide firearms to their children and immunize the parents from liability even if they know their kid is a deranged ape? As a society, we universally believe that parents should be responsible for our children's actions if parental negligence led to some form of injury. To my knowledge, all 50 states have parental liability laws on the books in one form or another. But at the same time, my perception is that we, as the gun community, seem to be skeptical about parents being charged for a crime when their child kills someone with a gun, even if the parent is aware, or should have been aware, that the child should probably not have a gun. So tell me what you think of the comments. Should Colin Gray be guilty of manslaughter, murder? Why or why not? I'm not your lawyer. This is not legal advice. Stay safe out there and have a great day.